And thank you everybody for joining this week's weekly Wednesday webinar, our 5-minute brainstorm. I'm Chris Orestes, and this week we're going to talk about the fear that advisors should have about the potential of being sued for not talking about life settlements. We've seen a rise in consumer activity holding advisors and agents accountable for missing out on a life settlement that they may have been entitled to. And it's an important topic area to discuss today. Because, as we all know, agents and advisors have a fiduciary responsibility to give to anybody they're working with the best and most comprehensive advice they possibly can. And quite frankly, it's a legal requirement as an agent or advisor to act in the best interest of the individual that they're representing and to operate without any self-interest or conflicts of interest. And one insurance option that some advisors are to this day still reluctant to talk about is life settlements. And that's a big mistake because it's become an area where policy owners have come back later to sue advisors for leaving out the fact that a life settlement may have been an appropriate alternative for them instead of lapsing or surrendering an unwanted or an unneeded life insurance policy. So if you're an agent or an advisor or attorney, an accountant, avoiding the topic of life settlements is a major error. It starts with the basic fact that life settlements are the legal right of the owner of a life insurance policy. Going back to 1911, when the United States Supreme Court ruled that life insurance policies are assets, and the owner of a life insurance policy has the legal right to sell their policy to somebody else through the transaction that's known as a life settlement. Life insurance policies are recognized as an asset, and the owner of that asset has the same personal property ownership rights as the owner of a home or any other form of asset. It has value, it is saleable, and nothing should impede the right of somebody to act on that asset, and no advisor should withhold information about that fact. And that's where the violation of fiduciary responsibility comes into play, and the exposure to legal action opens up. Remember, this has started to happen over the last few years where policy owners have been suing their advisors and the insurance companies for withholding this information from them about life settlements. And what I want to do is show you a couple of examples of cases that have been brought to court. Let's start with this first one, the Graham Bingham Irrevocable Trust versus John Hancock. In this lawsuit that was brought against John Hancock, they were sued for violating the Washington State Consumer Protection Act. And the court denied John Hancock's appeal for summary judgment that the policy owners should have already known about the secondary market, the life settlement opportunity on their own. And John Hancock was actually forced to settle this prior to going to trial. In Grill versus National Life, the policy owners lawsuit cited that it was a common and systemic practice of failing to inform and or concealing from the insureds the option of a life settlement in connection with their life insurance policy. The suit sought damages for purposefully omitting this information because the advisor and carrier knows other options, such as surrendering the policy or letting it lapse, would generate greater profits to the insurance company and advisor than a life settlement would. This suit ended up being settled out of court. And then Joseph versus Kay. In this lawsuit, similarly, the defendants sued the advisor and carrier for engaging in pervasive practice of instructing agents as well as independent agents that the life settlement transaction should be admitted or concealed as an option from the insured. This lawsuit sought compensatory, punitive, and treble damages and cited violations of California Consumer Legal Remedies Act, the financial abuse of an elder, and unlawful, unfair, and fraudulent business practices. Three case law precedents that are on the books in this country in recent years of the owner of a life insurance policy suing their advisor and the carrier for withholding the information about a life settlement, and the defense of saying that either they should have known about it before and it wasn't necessary for the advisor to tell them about it, or that the advisor didn't know that life settlements existed, has not worked. It is considered the responsibility of the advisor to be fully informed of any and all financial options for their clients to be presented to them so that the clients can make well-informed decisions about what is in their best interest. And agents should not be withholding any kind of information because they perceive that information to somehow not be in their best interest, the agent or advisor's best interest, versus what should be the only consideration, and that being the best interest of their client, the policy owner. So as precedent-setting legal actions across the country are being brought to court and resolved in disclosure versus concealment of information about life settlements, more and more advisors we're seeing are adding this information to their practice, both as a defensive measure to protect themselves from potentially being sued in the future, but also as a smart business practice. This is another standard mainstream insurance transaction that advisors can be bringing to their clients and adding to their practice. So it makes smart business sense, and it also makes smart defensive sense to make sure that an advisor is in a position that they can't be held later responsible for the perception that they withheld information that they should have known about and presented to their client. So I want to thank you so much for joining today's 5-minute brainstorm. Can advisors be sued for not talking about life settlements? And as we've discussed today, the answer to that question is most definitively yes. And we encourage you to do all you can to be in a position to not find yourself on the other side of an upset policy owner who discovers that, but for the lack of information, they may have received tens of thousands, hundreds of thousands, maybe millions of dollars from a life settlement. We look forward to joining you again on our next Wednesday weekly webinar, our next 5-minute brainstorm. We look forward to when we'll be talking to you again real soon. I'm Chris Orestes. Thank you so much.